Good morning, everyone. This is Mike Berger again with NC Planning, bringing you another Daily Counsel video. I wanted to jump on today and talk to you a little bit about the importance of your corporate governance documents, the importance of having the correct operating agreement for your limited liability company or shareholder agreement and bylaws for your corporation. Um, Corporations and LLCs are similar animals, right? They're entities that we form for our businesses to separate our business activities from our personal activities, our business assets from our personal assets. And what we're really trying to do is effectuate some type of limited liability shield, right? A shield around the individual that limits their liability from business activities. And as a part of that, you really need to have your corporate records, your corporate governance documents in place, intact, in compliance with the law, so that the company is operating at 100% efficiency and that no one can really contest that liability shield that you have in place. So today we're going to bring you the top 5 things you really need to be concerned about in an operating agreement or shareholder agreement with respect to your company. And so the first thing that one of these corporate governance documents is going to do is it's going to outline the ownership structure of the company. Who owns what, how much do they own, what's their percentage of ownership, and things like that. So it's really important in those documents to make sure that it is clearly defining ownership, what that means, and who owns how much. The second thing that is really important is that it's going to outline managerial authority, right? So this is number 2, managerial authority or director authority within a corporation. So typically in an LLC, we call our director or folks in charge of effectuating business managers, and in a corporation they're called directors. So LLC managers, corporation directors. It's important to outline that managerial duty, who is a manager, what they can do, are there any caps or limits on their spending, and you want to make sure that that is clearly defined and easily findable in the document. Thirdly, that we're going to look for in a operating agreement or a shareholder agreement in order to maintain that limited liability shield is that it's being done in compliance with the state law in which the company resides. So if you're a North Carolina company, you want to make sure that your operating agreement for an LLC or your shareholder agreement for a corporation is done in compliance with the law. That's going to make sure that, again, everything is aligned, the company's operating, it can't be out of compliance with the law, and that your limited liability shield around the individual from the business remains intact. Fourthly, we look for what is called buy-sell language. Now, I will tell you, this buy-sell language can be housed either in your corporate governance document directly, the operating agreement or the shareholder agreement, or you can have a separate buy-sell agreement that's been drafted maybe outside, and that's fine. You can run those things concurrently. But buy-sell language is essentially language that is going to cover a transfer of ownership in the event of death, disability, divorce, or insolvency of another member. So if someone who you are a co-owner of your business with passes away or becomes disabled, is unable to carry out their duties as a co-owner, as a co-manager of the business, then a buy-sell provision would go ahead and give you instructions, step-by-step, notice provisions, timing, dollar amounts, those types of things, of how those membership interests are to transfer from one owner to the next. Again, we call that buy-sell language, and we typically look for that to be housed within your corporate governance document, your operating agreement, or your shareholder agreement. Finally, for number 5, we look for voting or deadlock resolution language. So this is important in the event that there is some disagreement between owners and perhaps the votes aren't there, so to speak, to resolve the difference. Maybe the operating agreement or the shareholders agreement requires a supermajority to approve an action of the company, or just a simple majority. And for whatever reason, the way the votes have come in and shake out, they're not there to effectuate that activity one way or the other. And so we're in what's called a deadlock. The owners can't agree. And then the question becomes, is there some way to resolve this deadlock under the corporate governance document, a mechanism that the parties have agreed beforehand that, hey, if we're in this situation, this is how we're going to resolve it. So we look for that voting or deadlock resolution to be housed in your operating agreement or in your shareholder agreement and give direction to the reader of this is how we're going to resolve any deadlock in voting dispute that comes down the road. So there you go. That's your top 5 things we look for in an operating agreement or a shareholder agreement. Those are imperative to have in there. Make sure you're talking with your legal team, with your financial team to make sure these things are in place to set you up and your business up for success. Until next time, stay safe, and we'll talk to you soon.